So now let's continue our deliberations that we have immersed ourselves into legal culture this morning, and we're going to continue in that vein with Professor Dr. Joachim Savelsberg, whom I would like to introduce to you. He's a sociologist from the University of Minnesota, Minneapolis, professor at the Department of Sociology there, and currently fellow at our center. Professor Savelsberg studied sociology, economics, and public policy at the University of Cologne and received his doctorate in sociology at the University of Trier. After having received a number of prestigious fellowships both in Germany and the US, throughout his early career, he was appointed professor at the University of Minnesota in 1989. His publications cover a wide range of areas such as knowledge, law, crime and punishment, as well as human rights and comparative theory. They were recognized by several associations conferring the Outstanding Book Award or the Distinguished Book Award or Best Article Award. And the list of his honors, fellowships, editorships, visiting professorships is so long that unfortunately I have to cut this short so as to allow you, dear Joachim, to elaborate on your question here. Legal culture as memorial normativity. The floor is yours.
Thank you very much, Nina. It was Werner Gebhardt who invited me to talk about the question legal culture as memorial normativity. This was a generous invitation, but it also posed a challenge because I did not know what memorial normativity was, and I had to settle on some understanding of legal culture, and I will now talk about my answer to the question and the path which led me to this answer. Preliminary answer, yes. We can conceive of legal culture as memorial normativity. Memorial normativity constitutes and affects legal culture. In part, of course, there are aspects, are social norms that are also the product of memorial normativity, and there are aspects of legal culture that cannot be reduced to memorial normativity. Here is my roadmap. I will talk about some concepts that will lead me up to the memory norm link and the notion of memorial normativity. And then I will talk about memorial normativity as it informs legal cultures. I will tell you about an empirical story and then proceed inductively to arrive at some insights on the memorial normativity legal culture link. First, basic concepts. Legal culture, and I borrow from Werner Gebhardt here, is a symbolically and ritually mediated normative order of a legal community. And Werner Gebhardt adds a subordinate clause, it's substantially shaped by religiously inspired worldviews. And I would add, and memories and related practices would have to think separately about the relationship between memory and religious traditions. Of course, there would be a topic of its own. Secondly, norms are counterfactual expectations, the breach of which is sanctioned by a collectivity. The third central concept is collective memory, which I conceive of as notions of past events that are shared, mutually acknowledged, and reinforced by a collectivity, and these processes occur through rituals and symbols. This is the Durkheim and Halbwachs tradition, and they also occur through documents, as Karl Mannheim would insist. And these documents are biographies, historiography. They may also be court files, and in fact, I think they also include legal precedent. There is a particular type of collective memory that Jeffrey Alexander, Bernhard Giesen, and a group of scholars have developed and called cultural trauma, as something that is culturally constructed and mediated. I come to my first thesis. Memory entails and it generates norms. First, it entails norms, and I found some beautiful quotations from the classical and more recent literature. Durkheim says, "The traditions whose memory a system of beliefs perpetuates express the way in which society represents man and the world. It is a moral system and a cosmology as well as a history." Clearly, this tells us that memory and tradition entail morality, they entail norms. Edward Schills, in his famous book entitled Tradition, makes very similar argument, and I just took out one quotation here. There is a demoralization arising from the loss of contact with the ancestors. Being linked to the ancestors, being linked to tradition, remembering how things were done in the past, generates morality. Those of us who have ever seen The Fiddler on the Roof will remember Tevye, who would be very much with Edward Schill. He pleads for tradition, and we remember the musical sounds that come with this term. So memory entails norms and normativity, but memory also generates norms, or more precisely, actors use memory in order to plead for the enforcement and generation of norms. Daniel Levy and Nathan Snyder have developed this argument for a type of norm that I am personally particularly interested in, and I quote from their recent book on human rights and memory, where they say the global proliferation of human rights norms is driven by the public and frequently ritualistic attention to memories of their persistent violation. Again, memories are used in order to generate and enforce norms. Now, Levy and Snyder go a little bit further and make specifications. Number one, the memories they are concerned with are not national memories. They are not abstract universal principles either. They are cosmopolitan memories, something we might talk about later. And number two, they say that there has been a shift from what they call communicative memories that are bound to carrier groups, a Weberian term we all know, to cultural memories that they say are reproduced through media and communicative institutions that are much more removed from national contexts than carrier groups are. Now, occasions in which memory generates norms are religious rituals, commemorative sessions, legislative sessions, and I would say also court trials. That is where precedent is generated that is later introduced in later trials and put to practice there. In the realm of international human rights law, we find that traces also of procedural ideas make it from one stage to a next. The notion of the RICO law, the American law that was developed in the 1930s to fight organized crime, for example, made it into the Nuremberg Tribunal under the name of criminal organization, and from Nuremberg to the ICTY, the Tribunal on Yugoslavia, where it took on the name Joint Criminal Enterprise. So we see these traces of memory of past legal proceedings that make it into later legal proceedings. So memory generates and it entails norms. Now there's a reciprocal process that I would like to speak to, and this is that norms demand and steer memory. Here I would go a step beyond Maurice Halbwachs. Maurice Halbwachs, as many of us know, took a presentist position, which means he argued that the way in which we envision the past is structured by the interests of current day actors. I would add to this that the collective memory to which we subscribe is also affected by current day norms, where norms, of course, themselves may be a tool in the hand of interested actors that I will not exclude. They are general norms that we must remember. Zachor, remember, a term that appears in the Hebrew Bible frequently. In Deuteronomy, Moses says, remember the days of old, consider the years of the many generations. You must remember. Schills would have liked that. Durkheim would have liked this. This, by the way, is the quotation with which Jeffrey Ollick and Verret Vinitsky Ceruzzi and Daniel Levy begin the introduction to their prominent reader on collective memory. We all know the call never to forget. You must remember. Mr. Steinmeier said this yesterday, or the day before yesterday, on the commemoration of the 20th anniversary of the Rwandan genocide, and we've heard this call many times before. I have an image here from the Diakonie with a picture from the Congo, refugees in the Congo, which says, "The greatest catastrophe is the forgetting. Thus, we must remember." Memory, of course, does not just serve humanitarian purposes. It may serve aggressive purposes also. Mao Zedong coined the slogan, "Never forget the class struggle," which became a central slogan that helped pitch up the violence during the Cultural Revolution with all its excesses. We all know about Slobodan Milosevic and his mobilization of memories, and in fact even mythologies, in order to establish norms of aggression against other ethnic groups. So we must remember also in a particular way. This becomes clear when we understand that memory is always group specific, and that groups are involved in mnemonic struggles, which is struggles over the right, over the correct memory, and by implication also struggles over the appropriate and correct norms. These are struggles between cohorts, racial groups, ethnic, national, gender groups, and they're also struggles between the global level and the national level. I have a quotation here for illustration taken just 2 weeks ago out of The Guardian, the British newspaper, which printed a story about Serbian police in a Bosnian town destroying references to genocide from a memorial in a Bosniak cemetery. And the newspaper continues, "The graveyard's pad is a skirmish in a much bigger battle being fought in Bosnia, the continuation by bureaucratic means of the murderous 4-year war of 2 decades ago. It is a struggle over collective memory and the power to write history." It is not just social norms, it is also legal norms that tell us how to remember correctly. We know all about the legal regulation of hateful memories, of the use of certain symbols, the activation of certain rituals, and the telling of certain narratives that may be criminalized in some countries, even though they are not criminalized in other countries where the legal culture puts a greater emphasis on individual liberties. And I have the German-American comparison in mind, of course. I come to the last slide of my first part, which says, "Thank you, Werner. It was good of you to ask me to think about memorial normativity. This is a phenomenon we need to take seriously. It is based on the reciprocal relationship between memory and norms, and I define it thus here, normativity that is entailed in and generated by memories and that simultaneously regulates memories." This is my definition of memorial normativity with which I want to now work. And I come to part 2, which begins with my thesis 3. Memorial normativity constitutes and it affects legal culture. I want to illustrate the appropriateness of this argument by drawing inductively from a research project I have been engaged in recent years. This is a project on the collective representation of the Darfur conflict. And many in this room probably know about the Darfur conflict, a very violent conflict in the western part of Sudan, which pits the government of Sudan and the affiliated Janjaweed militias, which are recruited from nomadic groups, mostly defined as Arab groups on the one hand, and on the other hand, so-called black African tribes that are agriculturalists. This conflict has cost hundreds of thousands of lives, and it has displaced millions of people. I'm interested in representations of this conflict. By representations, I mean the acknowledgement. Do we take note of this suffering? I mean framing, secondly, which means do we think of this as a counterinsurgency? Do we think of it as a civil war? Or do we think of it as a form of criminal violence? And I'm interested in analogical bridging, by which we mean to take a past phenomenon, such as the Rwandan genocide, for example, or the Holocaust, in order to shed light on something that has not yet taken cultural form, something we don't have a clear understanding of, such as the catastrophe, the violence in Darfur. In order to understand about these representations, we conducted content analysis of 3,400 media reports and editorials. And I conducted interviews with Africa correspondents, Sudan specialists in foreign ministries, and NGO specialists on Sudan in 8 different countries. And we were particularly interested, of course, in the effect that interventions by the International Criminal Court had on the representation of the violence in Darfur. This is the empirical project within which, or the materials of which I want to use in order to approximate an answer to my question. The context, it has to be said, is the context of a new culture, a new global culture of human rights law. And I introduce a term here by my political science colleague Catherine Sicking, who talks about a justice cascade. By justice cascade, she means an almost exponential increase in the attribution of individual criminal liability to perpetrators of grave human rights violations. She identifies 3 different forces that contribute to this justice cascade: international prosecutions, stream 1, domestic prosecutions, which is by far the majority of prosecutions, by the way, and 3, a hard law streambed that leads from the Genocide Convention in 1948 all the way to the Rome Statute that was passed in 1998, and that became the foundation of the International Criminal Court that has now been at work since the year 2002. I argue that something essential is missing here in Sicking's account. What is missing is memorial normativity. Memorial normativity drives the entire process that she describes. This is the argument I want to make. And it leads from trials to memory, and it leads back from memory to trials. One slide on each of these parts. Trials to memory. Neo-Durkheimians, I think, have given us great insights into this direction of the causal path. Philip Smith at the Center for Cultural Sociology at Yale says that trials are speech acts in which society talks to itself about its moral identity, and Jeffrey Alexander, in his great writings on the cultural trauma of the Holocaust, applies this and argues that the MIT, International Military Tribunal, especially the charges of crimes against humanity, are a first step toward universalizing the Jewish mass murder as a cultural trauma, and he then moves on to the Eichmann trial and the notion of banality of evil. There is little doubt that this sort of memorial normativity created through the generation of cultural trauma became a strong motivation for the ad hoc tribunals of the 1990s and eventually for the Rome Statute. Trials to memory. The other causal path is memory to trials, and this brings us a little bit closer to my specific empirical theme. Initiating the Darfur prosecution was a speech by UN Secretary General Kofi Annan exactly 10 years ago, on the 10th anniversary of the genocide in Rwanda. This was a speech he gave at a commemorative session to the UN General Assembly, and he announced an action plan for Darfur, and he demanded swift and decisive action when, despite all our efforts, we learn that genocide is happening or about to happen. This action plan led to the creation of an International Commission of Inquiry on Darfur, which wrote a report and suggested to the UN Security Council to refer the case of Darfur to the ICC. And the ICC received the referral and issued charges all the way up to the president of Sudan, Omar al-Bashir. I thus conclude that global memories and norms, memorial normativity, are a central motor of a global culture of human rights law. I think that is undeniable. But I continue to argue, in the sense of the plurality of legal cultures, that there is, in addition to a global culture of human rights law, a variety of national cultures as well. And this is the next point I want to make. National, mnemonic, and legal communities, cultures of human rights law. And I want to give you 3 examples: the United States, Germany, and Ireland, because each of them allows me to make a particular point. US I call mobilization for human rights. The process of social mobilization on behalf of the Darfur, or intervention in the Darfur conflict, started with a genocide alert. By whom? By the United States Holocaust Memorial Museum. The Holocaust Memorial Museum has a dual mission: to commemorate, but also to use the memory of the Holocaust in order to alert the world when atrocities are again about to happen. This was in January of 2004. Holocaust as a reference point, the organization of Holocaust memory as a starting point for a campaign. In our media analysis, we found that in America, the violence in Darfur is categorized as genocide much more frequently than elsewhere, in 62% of all editorials compared to 34% of editorials in other countries. We found frequent use of analogical bridging, linking the violence in Darfur to the Holocaust, using the memory of the Holocaust in order to shed light on the violence that occurred in Darfur. And I have 2 examples. Both are editorials or op-ed pieces published in the New York Times and written by, not by chance maybe, an Armenian, Nicholas Christoph, who in 1 year before the referral to the ICC writes about Sudan's final solution. The Sudanese authorities, much like the Turks in 1950 and the Nazis in the 30s, apparently calculated that genocide offered considerable domestic benefits, like the long-term stability to be achieved by a final solution of conflicts between Arabs and non-Arabs. The references to the Holocaust are most obvious here. 1 year after the referral, he writes in another op-ed piece, Africa's brutal Lebensraum. As in Rwanda and even during the Holocaust, racist ideologies sometimes disguise greed, insecurity, and other pathologies. Indeed, one of the genocide's aims is to drive away African tribes to achieve what Hitler called Lebensraum, living space for the nomadic Arabs and their camels. Clearly, we have to understand the Darfur conflict in light of the Holocaust. This is what Nicholas Christoph tries to communicate to us. Other memories were mobilized. The Black Caucus in the US Congress became especially active on the case of Darfur, and it declared and explained its motivation because Black African groups with which African Americans identify were the primary target and victims of this conflict, at least in this somewhat simplified version of the conflict as we know it from American social movement organizations. The responses by the US government were swift for reasons that have to do a lot with the nature of American civil society and the nature of American government. Colin Powell, then Secretary of State, and very soon thereafter George W. Bush were the first leading politicians around the globe who declared the violence in Darfur to constitute genocide. 2 lessons from this story. First, carrier groups still matter. We encounter in this story Jews, Armenians, evangelical Christians that I didn't talk about, but that also played a central role, in African Americans. Carrier groups still matter, they still color the particular national shape of memories, and through that, and this is the next point, the temporary support for global human rights law that was a result of the mobilization in American society. I move to my second example, Germany, call it ambiguous culture of remembrance. What we encounter in Germany is a prominence, of course, of commemorative events and memorials regarding the Shoah. We all know this. In an article in the American Journal of Sociology, my former advisee Ryan King and I tried to categorize memorials and commemorative days and identified maybe what we are all mindful of. In the media analysis on Darfur, we found a prominence of the crime frame, frequent references to war crimes and crimes against humanity, but I put this in parentheses, some hesitancy to categorize as genocide and great hesitancy to bridge to the Shoah. This German culture of memory has normative implications. And I quote from an interview I conducted in the German Auswärtige Amt, where my interviewee said, "It is justified to be very, very sensitive and very careful and very restrictive in making such comparisons between the Holocaust and later genocides. However, I mean, since we have that particular burden of history on our shoulders, I think it should be an incentive for us to inquire into cases of genocide. We have all reasons to maintain that we as Germans have a particular responsibility to make sure that any Holocaust or any genocide or any crime against humanity is not reproduced." Clearly, a normative conclusions coming out of the solid memory of the Shoah in Germany. Is this just rhetoric? A recent study by political scientist Karen Smith, comparing responses by different European governments to a number of different genocides, concludes that indeed the German responses are more decisive, more articulate, more willing, at least in the rhetoric, to intervene in cases of genocide. Next slide I call Same Memories but Competing Normative Demands. And I begin this with a quotation from an interview I conducted with a young prosecutor who is the head of the impunity group of Amnesty International Germany. She had worked previously at the ICC and at the tribunal in East Timor. In our interview, she made an interesting observation, said, "The churches are much engaged in this respect, in part out of humanitarian concerns, but also with a view to their own past. And the churches have a major impact in Germany. Still, it's more humanitarian motivation. Many people are engaged in humanitarian charities. I would always apply it as a criminal law lens, but only few people do." What we learn here is that the memory of the Holocaust can lead to different conclusions. It can lead to conclusions that strengthen a global culture of human rights law, but it may also lead to conclusions that demand humanitarianism as opposed to criminal legal intervention. I could give you similar quotations that I have from interviews with diplomats who are very concerned about the working with the Sudanese government on behalf of the North-South conflict, the comprehensive peace agreement, and that were skeptical thus for a human rights legal intervention. Again, lessons are that carriers matter, policymakers, churches, humanitarian charities, and that there may be conflicting lessons from Shoah memory and ambiguous contribution to a global culture of human rights law arising from the German case. I move to my third example, Ireland, which I call competing memories. Interviews in Ireland and our understanding of the nation and any walk to the city of Dublin and its memorials will tell us that the dominant memory, collective memory of Ireland is the memory of extreme poverty and the famine that cost thousands and tens of thousands of lives of Irish people. It became obvious to me in my interviews in Dublin that this competing memory, this competing cultural trauma that dominates in Irish society leads to different normative demands than the strengthening of the culture of human rights law. And I quote from the Department of Foreign Affairs, "We always point to the history of our aid program, that it has very strong roots. Also in Sudan, a lot of our focus was humanitarian. We fund missionaries, we fund Catholic NGOs. Irish policy is aligned, but it's also with a particular focus. We have no axe to grind. We got a little bit more weight in Sudan when we say we come particularly for the delivery of humanitarian aid." Again, this is not just rhetoric, comparing contributions or the portion of budgets for development and humanitarian aid. Ireland ranks third within Western countries, of course, controlled for gross national product. This has implications for the culture of human rights law, and I give you one more quotation from my interviews at the Foreign Ministry. "Ours is an impact lens rather than a causality lens. It has always troubled me with regards to the likes of the ICC and how one attributes responsibility, and I always feel that people are quick to attach responsibility and draw conclusions. Sudan would certainly not be alone if the impunity road was taken. Multivariate analyses of our 3,400 cases, articles and editorials indeed confirm the lesson from the Irish case. Focus on humanitarianism leads to a weakening of the categorization of violence as criminal violence and as genocidal violence." Interesting also is that collective memory can take organizational shape. The Irish Foreign Ministry has a working group on the Northern Ireland conflict in order to examine what lessons can be drawn for other conflicts that Irish foreign policy engages with. And one of the central lessons, according to my interviewees, is that amnesties at times are more effective in putting an end to cycles of violence than criminal prosecutions. Lessons here again, there are carrier groups, the Catholic Church, maybe the Irish nation as a whole, and there may be competing national memories that may weaken the culture of global human rights law. Come to my concluding slide. What I think I was able to illustrate is that there is a plurality of overlapping but distinct memorial normativities across nations and between the global and the national levels. Memorial normativities receive support and they receive challenges, and they pose challenges to a new global culture of human rights laws, which happens through a number of mechanisms: carrier groups, civil society mobilization, organization trials, rhetoric devices, competing normative implications of memories, the German Humanities case, and competing memories such as the Irish case. Importantly, the concept of memorial normativity seems to make sense to me, and in fact, memorial normativity constitutes and it affects the culture of law, in this case of human rights law, ritually and symbolically mediated order of a legal community. This is what I wanted to tell you. This is what I came up with in response to your challenge, Werner, and I hope I didn't disappoint you too badly. Thank you so much.